A plea to Judge Roberts. Please protect our property. Part 1, The Flood. Hello, I'm Joe Petrina, founder of the Hoodwing.net website, examining the illegal taxation of private American homes. Initially, my focus was on home and vehicle taxation, but more recently, political forces have eyed our financial belongings, and this river about to flood really got me going. Recently, the U.S. Supreme Court tipped its toe into the waters of private property protections, and the timing couldn't be better. For decades, people have felt the affordability crunch of assessment-based home taxation, but this pales in comparison once political forces begin to levy taxes on other property classes. As the video explains, assessment-based home and vehicle taxation is not simply unaffordable, it's unconstitutional. And so, if this ingrained habit of property taxation is allowed to stand for homes, assessed taxation of our financial holdings is certainly next. To stem this, a constitutional halt needs to be made across the whole topic of property taxation. The legal centerpiece: only commercial activity can be taxed. And because our dormant belongings make no money until sold, in the meantime, there is nothing to tax. We simply ask that programs like mandated free K-12 education are funded correctly using taxes applied to commercial activity, like sales, income, and capital gains. We want the government to leave dormant belongings alone, and not just our homes and cars, but our financial savings as well. The Constitution was never amended to permit taxation over the people's personal assets. There is only the 1913 Amendment, which allows income taxes set at different rates for different incomes. But this amendment only applied to income, not property. Why then, you may wonder, hasn't property taxation been challenged in the courts? The answer, and most people don't know this, is that since the country's founding, key property disputes have been adjudicated solely by state courts, which politically often protect state budgetary agendas. The U.S. Supreme Court never took these cases, seeing them as local internal state conflicts. But then, in 2019, for the first time, Chief Justice Roberts invited property cases brought to the federal Supreme Court. For details on this ruling, see the Rosemary Knick versus the Township of Scott, Pennsylvania case. As Judge Roberts put it, we now conclude that the state litigation requirement imposes an unjustifiable burden on the property owner's claim that his or her land has been effectively taken for public benefit without the government paying just compensation. It was because of this U.S. Supreme Court breakthrough that I organized my property research into this video. I want to get constitutional movement going against taxation of dormant homes and family vehicles. And in doing so, I want to arrest the recent wealth tax campaign to tax our savings. Digging deeper, the Constitution's origination clause solely authorizes legislatures and not towns or cities to levy taxes. And these taxes can only apply to transactional activity, like wages, sales, tolls, and profits. In other words, because the states themselves can originate sales and income taxes to pay for all of their mandates, shouldn't we get them to do their complete revenue-producing job without attacking our homes, cars, and savings accounts? Yet as clear a proposition as this is, there is more. In addition to the tax origination clause, at least 6 other constitutional provisions prohibit private property taxation. The video you are watching covers these and prevents 3 layers of legal protections. It starts with our natural rights to life, liberty, and property, which sit above the reach of government, meaning that no written law or judicial decree can override these. Second, 7 constitutional clauses uphold these natural rights by detailing the privileges and limitations sitting between the individual and the government. Finally, historical precedent builds out the history of property rights from biblical times through English history and into the American era. As such, American law offers a multi-layered system of safeguards that we can call upon to reverse the current trajectory of government overreach. To pursue this strategy, a constitutional law firm is sought to design a multi-state class action suit against the governors, demanding they shut down property taxation in their respective states. Unencumbered liberty as a birthright cannot coexist with socialist domination of society. Accordingly, to protect our natural rights, the Supreme Court of the United States interprets due process broadly. In its deliberations, the court considers procedural and substantive due process, plus it also looks to prevent the creation of vague and subversive laws like equity justice, which is a favorable status for some with equal treatment under the law ended. Examples of vague laws like this were even described by Lysander Spooner back in the 1800s. He explained it this way: legally speaking, the term public rights is as vague and indefinite as the terms public health, public good, public welfare, and the like. These have no legal meaning. Due process, therefore, ensures the minority rights of citizens against the various forms of tyranny, including made-up law. With due process, in the case of property, under the current U.S. Constitution, neither popular voting, activist judges, nor government legislation can authorize wealth taking from one's home, bank account, investment portfolio, or any other asset simply to fund municipal, state, or federal budgets. Because socialists know that politically they cannot amend the Constitution using the 3/5 ratification rule by the states, their tactic has evolved into ignoring criminal constitution and election laws, inhabiting deep state power jobs for life, corralling media and union backing, and using street terrorism and big tech cancel culture armies to smother opposition. Quite an operation. Lenin and Trotsky would be impressed. Congratulations. Realize that the non-elected ringleaders who run these various socialist power centers cannot be voted out of office, and that our marginalized elected representatives do not control the syndicate of socialist institutions. And so, politics cannot be relied upon to solve the problem. In recent times, the U.S. Supreme Court passed on intervening into both Obamacare and election fraud, as it felt these conflicts better addressed through political channels and voting. But property is different. Our natural right to property, by definition, rides above politics, and so a definitive firewall protecting property requires a landmark court ruling. Way back in 1855, the U.S. Supreme Court decision on the Murray's-Leasey versus Hoboken Land and Improvement case, Justice Curtis said the words due process of law were undoubtedly intended to convey the same meaning as the words by the law of the land in Magna Carta. The article is a restraint on the legislative as well as on the executive and judicial powers of the government, and cannot be so construed as to leave Congress free to make any process due process of law by its mere will. In my words, the government is not in charge of everything, and certainly not in charge of my house, car, or savings. So the question becomes, are we to be a nation of inalienable natural rights to property or not? I pray that the court can muster the courage to take on such a case and not be blackmailed into staying quiet through political threats of court packing. I ask the court to reinstate America's law of the land, retire property taxation. Overall, if the court does not uphold property law, the anti-constitution fractions now running through society and the government will prevail. So with the socialist flood as the big picture, we next turn to part 2, understanding natural rights. A plea to Judge Roberts. Please protect our property. Part 2, Understanding Natural Rights. Welcome back to A Plea to Judge Roberts. Here in Part 2, we review natural rights. For those familiar with the legacy of Thomas Jefferson, his concept of natural rights to liberty, life, and property still ring true. In the Declaration of Independence, natural rights are defined as inalienable, neither able to be given away nor taken away by any operation of government. New laws, executive and judicial decrees cannot interfere with natural rights. Natural rights are our law of the land. To see what is meant by natural rights, let's examine the rights to bear arms, to free speech, and to private property found in the U.S. Constitution. First, a look at life and the right to bear arms. Quite simply, if you have a natural right to life, then certainly you have the corresponding right to defend yourself, and this means defense from all comers, including criminals and oppressive political regimes. As Jefferson put it, the strongest reason for the people to retain the right to keep and bear arms is, as a last resort, to protect themselves from tyranny of government. This natural right to life is diminished, therefore, whenever government limits your ability to defend yourself. Hence, by definition, your natural rights to both life and arms need to sit above any operation of government. Next, let's look at liberty and free speech. When I took a class on free speech taught by the dean of Yale Law School, no one in class could define free speech. We tried, but the dean dismantled all of our guesses. Finally, he let us off the hook explaining, everything American starts with we the people. People run the government, not the other way around. Authority over government is why freedom of speech exists. Unfettered dialogue amongst ourselves is essential for us to pilot our subordinate government apparatus. Then he continued, freedom of speech, the right to influence the political opinions of others out in the public domain, has no restraints. This includes hate speech, agenda media, and even falsehoods claimed against public officials, so long as the optic is political. Non-political falsehoods, such as defamation or yelling fire in the theater, are both illegal. Thank you, Professor. And so, because freedom of speech is a natural right forming the heart of liberty, it implicitly sits above government. Now let's look at property. As with life and liberty, property also sits above government. Property, therefore, is not to be encumbered by any government operation. Specifically, the taxation of private homes and family cars and the practice of applying commercial code to homeowners all violate the U.S. Constitution. Due process forbids interference with any natural right, including property, yet there are many opponents of property amongst us, and through this political threat, our natural rights are now at stake. Originalists interpret the Constitution verbatim, and evolutionists say it should be adopted to meet current circumstances. Yet, most in both camps still agree that free speech sits above government authority, though cancel culture people are now crossing even this line. Inconsistently, however, the two camps part company when it comes to property, even though property stands elevated on the same we the people perch. Conservative originalists maintain that Americans fully own private property with absolute rights to homes, savings, cars, and so forth. Conversely, socialist evolutionists believe that property, unlike speech, stands subclassified with limited rights, molded by the evolving needs of government. As things stand, the U.S. Constitution was never amended to subclassify property in this manner. Such an amendment would repudiate the whole we the people foundation, placing us and our property below the government. To circumvent this, and without a battle waged over legal standing, state legislatures simply invented tax lien home confiscation devices designed to intimidate us. These tax statutes ignore the Constitution and in doing so degrade both natural rights and affordable living, We actually pay to live in our own homes and to drive our own cars. It appears that our properties have been unlawfully subjugated by the very politicians chosen to represent us, our natural rights discarded. Want to do something about it? To do so, we need to dig into the key clauses of the U.S. Constitution designed to protect natural rights. Coming up next in Part 3. A plea to Judge Roberts. Please protect our property. Part 3, Constitutional Clauses. Welcome again to A Plea to Judge Roberts. Here in Part 3, we review the key clauses of the U.S. Constitution designed to protect our homes, family cars, and life savings from government overreach. In Part 2, we looked at our natural rights to life, liberty, and property, but these rights need to be fleshed out further if our natural right to property was to be defended against government overreach. This is where various clauses within the U.S. Constitution come in. Here in Part 3, we are focused upon the 7 clauses which specifically protect property. Consider this: if one's house is up for grabs, then one's monetary savings can't be far behind. Okay, here goes. Regarding real and movable property, like one's house and car, many do not realize that homes and family vehicles are protected by multiple constitutional clauses, including these 7 provisions: tax origination, indirect taxation, property taking, due process, contract, direct taxation, and equal protection clauses. These firewalls absolutely forbid the taxing and taking of your home, family vehicles, and financial savings. They are our law of the land. And though systemically violated, they have never been constitutionally amended. We start with number 1, the origination clause. It simply says that all taxes must originate in the legislature, nowhere else. In other words, municipalities, which are places, not legislatures, have no taxing authority. Yet they tax everyone. Next comes number 2, the indirect taxation clause. This clause allows legislatures to tax money-making commercial activity, like sales, wages, capital gains, and tolls. Conversely, our commercially inactive homes neither make money nor create financial transactions, and hence they cannot be taxed. Until sold, there is no commercial activity. As to number 3, the property taking clause, it solely authorized property taking for eminent domain public use projects like building a highway, where the owner is fully compensated. No other taking is permitted. Yet some municipalities criminally take and sell homes from under people to collect the home and vehicle taxes their state legislature never levied in the first place. In doing so, municipalities circumvent both the legislature and the courts, brazenly bypassing number 4, the due process clause. It's the Wild West all over again. By the way, house confiscation has a fancy label, something called a non-judicial take. I just call it stealing. Thankfully, there are federal laws in the books to protect us from misdeeds like these. For example, RICO criminal laws prohibit institutional racketeering. For instance, municipal institutions using invented tax authority to intimidate households into paying made-up taxes are operating a classic RICO syndicate. Next, let's examine number 5, the contract clause. In the American liberty system, individuals are supposed to live unencumbered. Parties become obligated solely through a mutual agreement called a contract. Whether between people, between a person and a business, or between homeowners and their local municipality, the rule is no contract, no obligation. Or as Benjamin Franklin would say, don't tread on me. In case you didn't know, municipalities are regular corporations like McDonald's hamburgers. Corporations, even municipal corporations, cannot impose unilateral contracts on you just because you reside in their district. Again, parties must mutually agree for a contract to be in force. And as we all know, most homeowners are not under contract with a municipal corporation. So neither formal nor tacit obligations are in play. But here's the rub. Most homeowners are under contract with their mortgage lender. And to get a mortgage, banks obligate homeowners to pay the illicit taxes. And so, in court, municipalities with evidence of a contract have no standing against you whatsoever. Banks, however, do. Then there are those few who own property free and clear. Without a bank acting as a heavy, many municipalities revert to raw taking of these homes and do so without court involvement. And in defiance of the narrow eminent domain authority of number 3, the property taking clause mentioned earlier, one crime, bogus home taxation, leads to the next crime, wanton taking, both trampling the residents' civil rights. Hope you're following all this because there's more. Let's next look at number 6, the direct taxation clause. Interestingly, direct taxation, a long forgotten clause, allows both real estate and people to be taxed, but only at some uniform amount. For example, $1,000 per year for each person over the age of 21. Congress' last use of direct taxation was after the War of 1812, when each adult had to chip in a standard amount to pay for the war. If you were a slave, your owner only paid 3/5. As unseemly as this appears, uniform direct taxation across the population is the only property tax option sitting in the government's constitutional toolbox. And strangely, it's never used. Conversely, though currently used everywhere, variable household by household assessed value taxation is not permitted whatsoever. In other words, your local tax assessor operates fraudulently, projecting a false authority to set your tax obligation that he or she does not actually have. In court, projection of false authority by government officials constitute yet another crime called color of law. Note, however, and I've done the math, that a legal 1,000 direct tax on all adults would easily cover the cost of local police and road maintenance. So it could finance local services truly shared in common. Finally, in our quest to protect property, there is number 7, the Equal Protection Clause. Supposedly, everyone is treated equally under the law, yet municipalities habitually award side deals to privileged taxpayers. For example, no tax for 5 years if you open a business in our town. Both parties, the business person and the municipal corporation, circumvent the law of the land to bolster their self-oriented agendas. Sadly, this gross behavior is never prosecuted, as state-level justices allow their fellow state municipal friends to do whatever they want. But there is hope. Never forget that in America, our natural rights to life, liberty, and property stand inalienable, neither able to be given away nor taken away, even after faulty precedent has trashed these rights for decades. Structurally, by being inalienable, natural rights sit above the reach of local government. This means that with the stroke of a pen, Supreme Court intervention could rightfully end the taxation of dormant homes and family autos and block any attempt to tax one's financial assets. As for existing programs, free K-12 education and state administrative code programs could continue, but only if funded by the legislature using sales income and other transactional taxes. If America is to return to traditional constitutional standards, we can no longer tax property to finance government programs. With at least 7 constitutional clauses violated and many criminal statutes ignored, a dilemma of this magnitude belongs up with the U.S. Supreme Court. The question becomes, will the highest court even consider overreach cases? And if so, will the court stand for we the people, or like the local courts, rule for their partners in government? It's now or never. Time for the justices to take a stand. But there is precedent to help them deliberate. Let's go back in time and revisit the foundation of property rights throughout history. Coming up next. A plea to Judge Roberts, please protect our property, Part 4, the history of private property from biblical times through to Old England. You are watching the 8-part series titled A Plea to Judge Roberts, Please Protect Our Property. Here in Part 4, we cover the ancient history of property rights and consider judicial rulings regarding property from as far back as biblical times, continuing through Old England. Let's step back through time, 4000 BC. You may recall the biblical passage where God grants humans dominion over all the earth and over the fish of the sea and over the fowl of the air and over every living thing that moveth upon the earth. In these early years, everyone took what property they needed, so long as no one else had use of it. Back then, we were wanderers, and temporary ownership was the law of the land. Or as Cicero, the Roman, put it, the world was a great theater which was common to the public, and yet the seat which any man had taken was for the time his own. 2000 BC. But over time, though the land's endless expanse was often used in common, fixed possession did exist, as in the case of Abraham's water well. This is explained by William Blackstone in his 1700s commentaries on English common law as follows. Thus we find Abraham, who is but a sojourner, asserting his rights to a well because he had digged that well. And Isaac, 90 years later, reclaimed this, his father's property, and after much contention with the Philistines, Isaac enjoyed it in peace. 1000 BC. Next, as mankind's population expanded into the millions, migratory living transitioned into farming, with people needing to tend the land and their livestock to survive. Fixed possession of both real land and livestock became an essential feature in the new law of the land. Again from Blackstone's commentaries. It was clear that the earth would not produce her fruits in sufficient quantities without the assistance of tillage. But who would be at the pains of tilling it if another might watch an opportunity to seize upon and enjoy the product of his industry, art, and labor? So even back then, it would seem one ought to keep the fruits of one's labor. 500 BC. As populations boomed further, absolute property rights were concentrated into the hands of royal families, with feudal grants of limited favors sifted down the chain, except in one instance. It was only in the Germanic world, specifically within the Angles and Saxons of modern-day Denmark, that mere individuals also held absolute title in the manner of kings. Having absolute title was termed allodial title, meaning real property held independently of any superior landlord or chief. Allodial property owned by Anglo-Saxon freemen was not encumbered by forced rents or taxes. 400 AD. After the fall of Rome, the Anglo-Saxons invaded England, and under their common law, they owned English land with absolute allodial rights, rights coming from God, unassailable by other men, hence the moniker, freemen. In coming from God, allodial ownership was inalienable in that it could not be taken by any operation of law for any reason whatsoever. Englishmen enjoyed unfettered, inalienable rights for hundreds of years. Allodial property was their law of the land. Winston Churchill explains this in his History of the English-Speaking People. Within this society of freemen, each person, together with their fixed and movable property, controls himself with no obligation to the chief. One's allegiance to the chief stays voluntary, primarily concerned with defense of the community and nothing else. The Saxon freeman's right to allodial autonomy encompassing one's property becomes the foundation of English common law, law still in effect in both the United Kingdom and the United States today. Winston Churchill. 1066 AD. But then, in 1066, on the Hastings battlefield, the Norman Duke William the Conqueror defeated the English king Harold Godwinson. On the battlefield, under the sword, many English lords ceded their allodial estates to William, who now had allodial titles across much of England. William graciously offered feudal arrangements to the defeated English lords, allowing them to return to their ancient family estates. But with feudalism, William alone held allodial title to the estates. This meant that each English lord enjoyed his estate only at William's pleasure, with military vassalage and taxation obligations to boot. Allodial ownership allowed William to rule by divine right, where a monarch is subject to no earthly authority, possessing the right to rule directly by the will of God. In this configuration, the king is a dictator, able to have anyone killed or canceled at will. And so, through conquest, William obtained allodial title over most of the largest English estates, but notably, he did not obtain title to lands not yet in English sphere, such as Scotland, Ireland, India, South Africa, Australia, or America. 1215 AD, a few centuries later, to contain the dictatorial excesses of William's heir, King John, you might have heard of him, other English lords forced King John to sign the Magna Carta. This groundbreaking contract gave Englishmen the right to due process for any government challenge against the individual. This meant more than needing to prove a criminal charge in court as a procedural matter. Due process recognized a natural liberty that individuals possessed, which could not be stolen arbitrarily. Though the king still retained allodial title to the land and continued with the practice of allocating feudal estates to his favorites, prosecution of subjects now followed due process according to the new law of the land, which prevented injustice based upon the whims of the monarch. As in the old days of freemen, once again, English people had reclaimed at least part of their natural rights. The writ replevin came into practice in England. Replevin is an action brought by a tenant seeking the return of movable property seized by his lord to satisfy a claimed debt owed to the lord. If the tenant instituted a replevin action and gave security, the sheriff could order the lord to return the property at once, pending a final judgment in the underlying dispute. The landlord could always stop the action or replevin by proving to be the owner of the goods. Hence, the process of quiet title begins, the need to quiet claims to title by determining the true owner. And if you are the true owner, no one can encumber your property in any manner. Through replevin rights, the raw taking of private property ended in 1300. Yet today, we find municipalities stooped in the home-taking habit. 1620 AD. Most do not realize that when the English colonized America, no legal authority controlled land rights in the American wilderness. Both English and Native Americans operated in a vacuum, absence of rights. One simply occupied land in a lawless setting. 1662 AD, 40 years later, King Charles of England, to fill the legal void, and without conquest, assumed allodial title of the whole of New England. And like the Wizard of Oz, he issued invented land grant charters to Massachusetts, Rhode Island, and Connecticut. The charters decreed a system of property rights where one may occupy land in fee simple, meaning land use with minor strings attached, where the king still retained allodial title, granting use of the land under feudal decrees and minor taxation. 1776 AD, getting closer. After the French and Indian War of the 1750s and 60s, the English king, looking for revenue, asserted his long-forgotten allodial rights over the American colonies, forcing aggressive taxation, troop quartering, and random searches of property upon the American subjects. This was all legal. The 1660 Charter said so. It was in this time frame that Thomas Jefferson deconstructed the king's claim to a allodial title in the Americas. Jefferson pointed out that, unlike the Battle of Hastings, where in defeat the English knights voluntarily ceded a allodial title to William the Conqueror, that in America, no such title existed anywhere in the wilderness, and therefore no title of any kind could have been ceded to the king, either through battle or through some other concoction. Jefferson exposed the king's claim to a allodial title as invented and fraudulent. Jefferson himself concluded, America was not conquered by William the Norman, nor its land surrendered to him or any of his successors. Possessions are undoubtedly of the absolute disencumbered nature. And so the idea of absolute property ownership took root in the minds of the colonists, helping to fuel the American Revolution. Which brings us to American historical precedent presented in the next segments, starting with the American Revolution. A plea to Judge Roberts, Please Protect Our Property, Part 5, The American Revolution. You have arrived at Part 5 of the series titled A Plea to Judge Roberts, where we examine the birth of America's unique set of rights held by every citizen. As the previous ancient history section illustrates, the American system of law was not pulled out of thin air, but was a refinement of what came before. Let's pick up the story in 1783. Following the American Revolution, England signed the Treaty of Paris, foregoing the king's claims to land inside the 13 colonies, thereby ending the invented feudal obligations of the states to the crown. At this juncture, the founders considered the right to own property to be a natural right and a allodial right possessed by all human beings, not something granted by government. The fundamental purpose of the Constitution was to secure this natural right for all American citizens in their pursuit of happiness and ultimately in their pursuit of property. Property in the American system included everything one can consider mine, including land, belongings, beliefs, speech, life, liberty, and the exercise of one's intellectual faculties without being canceled. The Bill of Rights was drawn up to defend this broad definition of property. Absent of crime, you were to be left alone by government agents. Government's sole mission, promote a political environment where everyone can make the most of their natural right to property. Government certainly did not exist to accelerate one's acquisition of property, nor to encumber one's accumulated property via taxation and regulatory restrictions. As Jefferson explained, the policy of American government is to leave its citizens free, neither restraining them nor aiding them in their pursuits. This obligation of the American government to protect property of all types reaches back to Old English common law cited in Chapter 39 of Magna Carta as follows. No free man shall be seized or imprisoned, or outlawed or exiled, or deprived of his standing in any other way, nor will we proceed with force against him, or send others to do so, except by the lawful judgment of his equals or by the law of the land. In the above passage, Magna Carta compels government to follow the law of the land in scrutinizing any action against a citizen, including action against the property of a citizen. In protecting one's natural rights, the American law of the land sits above the reach of invented law. 1788, the former colonies then ratified the U.S. Constitution. Specifically, the federal government was not given any allodial rights to property within the 13 states, and reciprocally, no citizen had feudal obligation to the federal government. Beneath this, the individual states could decide their own property laws so long as the states respected provisions in the Bill of Rights, sanctifying absolute title to private estates, due process, and many other protections. The due process principle was first presented in the Fifth Amendment. It states that no person can be deprived of life, liberty, or property without due process of the law. The counterforce to due process is police power, the general obligation of the government to regulate citizen behavior for the safety, health, and welfare of the peoples. The Fourth Amendment of the U.S. Constitution establishes the line not to be crossed in exercising police power. It states that the right of the people to be secure in their persons, houses, papers, and effects against the unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. This power to invade or take property was made as narrow as conceivably possible. 1791, Thomas Paine memorialized natural rights in his Rights of Man publication. It states that natural rights are those which appertain to man in right of his existence. Of this kind are all of the intellectual rights or rights of the mind, and also all those rights of acting as an individual for his own comfort and happiness, which are not injurious to the natural rights of others. But soon, many digressions away from natural rights stirred in the wind. In the next segment, we trace key state and Supreme Court property law precedents of the 1800s. Some were for and some were against property owners. Let's check it out. A plea to Judge Roberts, Please Protect Our Property, Part 6, Property Precedents in the 1800s. This is Part 6 of a plea to Judge Roberts covering property precedents of the 1800s. Here we will watch lawmakers grapple with the application of property rights during the first 100 years of the country. Just before the Civil War, the question of natural rights came front and center. Did we all have natural rights to life, liberty, and property, even the slaves? Let's pick up the story in 1856. At the onset of the Civil War, due process for the individual formed the foundation of the Republican Party's 1856 platform against the spread of slavery. The 1856 platform stated, "Our Republican fathers ordained that no person should be deprived of life, liberty, or property without due process of law. We deny the authority of Congress, of a territory legislature, or any individual or association of individuals to give legal existence to slavery in any territory of the United States, while the present Constitution shall be maintained." The Democrat response asserts that due process privileges refer to the slave owner, not to the slave. Natural rights are vested only in some, and this view was supported by the Supreme Court during the Dred Scott case. The slave, named Dred Scott, claimed that once on free soil, he became free. Well, freedom for slaves in this manner was a theory that Judge Taney of the U.S. Supreme Court could not tolerate. Judge Taney wrote, "An act of Congress which deprives a citizen of the United States of his liberty or property merely because he brought his property into a particular territory and who committed no offense against the laws could hardly be dignified with the name of due process of law." In other words, Dred Scott remained a slave, even on free soil. Justice Taney classified Dred Scott as property, not as a human with natural rights. Justice Taney may have been our first activist judge, someone ignoring written law. After the Civil War, as part of an attempt to circumvent due process, Democrats put forth an argument saying that due process, though a natural right, modulating law, only applied at the federal level. Due process, they propose, does not obligate states for local circumstances. To counter this, in 1868, the Republicans, who controlled Congress and two-thirds of the states, passed the 14th Amendment, clearly asserting that due process applied to all levels of American government. To cement this, the 14th Amendment introduced a concept called substantive due process as compared to procedural due process. Procedural could mean as little as proper notices being sent to a citizen on some matter. Substantive measures in the 14th Amendment protect citizens from executive, judicial, and majority vote decisions that fundamentally exceed the limits of government authority. For example, a majority vote in a municipality to raise property taxes where no authority exists in the first place, this local practice has no standing under the 14th. The 14th Amendment restated hundreds of years of common law tradition within our law of the land. Due process refers to the lawful extent of government and not simply to the procedural technicalities. In 1877, anti-property forces on the Supreme Court soon wiggle around the concept of absolutely owned private property. In the Munn versus Illinois case, Illinois wanted to dictate the rates Munn, a grain elevator business, could charge for its services. The U.S. Supreme Court ruled against Munn, saying, property becomes closed with the public interest when it is used in a manner to make it a public consequence. When one devotes his property to a use in which the public has an interest, he, in effect, grants to the public an interest in that use. Private property suddenly became public property when closed in the public's interest, whatever closed refers to. This ruling, centered around economic interests, makes a key pivot from one's natural rights to property, moving down the road towards socialism. Still, one should note, the court never considered non-commercial private homes fair game, only commercial activity. Assuming that no crime has placed a victim in immediate danger, government's sole authority in private property is eminent domain confiscation. Eminent domain gives the government the right to take property for some extraordinary public good, like building a highway, but only if the owner is justly compensated. For example, in the 1890s, in the United States versus Gettysburg Electric Railroad Company, the Supreme Court ruled for fair compensation to the railroad company that owned parts of Gettysburg Battlefield when it became a national park. This obligation of the government to the property holder is spelled out in the Fifth Amendment as follows: nor shall private property be taken for public use without just compensation. But in no way does eminent domain give government the right to take someone's house in order to collect taxes from the property owner. It's just the opposite. The government has obligations to pay property owners. As we all know, the 1800s in America had its ups and downs, but overall, something would come along, like the Civil War, to keep the ideal of life, liberty, and property alive. Let's move to the 1900s. A plea to Judge Roberts, please protect our property, Part 7, property precedents in the 1900s. Here in Part 7 of A Plea to Judge Roberts, we continue from the previous segment that covered the 1800s to review American property rights in the 1900s. Let's start 1877 to 1954 AD. After the Civil War, the slavery issue was barely solved. Though former slaves now had the same natural rights as did others, loopholes still existed. After the war, Democrats looked for workarounds to natural rights, leading to the notorious Jim Crow laws passed in 1877 by Southern Democrat-controlled legislatures. Using the separate but equal argument, Jim Crow laws finessed the assertion that all men are created equal by asserting that one could still be separated even if equal, like chickens all equal placed in different coops. Jim Crow discrimination would only be dismantled in the 1950s and 1960s through both court and legislative means. In 1954, the U.S. Supreme Court ruled that separate public schools were unconstitutional, but it took a full act of Congress to go beyond the scope of school segregation. The Civil Rights Act of 1964 finally broadened the scope, outlawing discrimination based on race, color, religion, sex, or national origin, and it prohibits discrimination in public places such as schools, restaurants, and workplaces. This one topic, Asking if everyone's natural rights were equivalent under the law took a civil war and 100 years to answer. But other property and natural right conflicts occurred in the first half of the century. 1905. In 1905, the Supreme Court case Lochner versus New York limited the ability of the states to wantonly corrode the property rights of the citizens of New York State. Though the forefathers designed the U.S. Constitution to leave some property law in the hands of the states, this did not mean anything goes, something the Jim Crow era temporarily got away with. In the Lochner case, New York State passed a law butting into the private businesses of local, mainly immigrant bakers, telling the bakers they could not work. You want me to do that again? All right. Not bankers, bakers. Here we go. In the Lochner case, New York State passed a law butting into the private businesses of local, mainly immigrant bakers, telling the bakers they could not work more than 10 hours per day. The state law was struck down, the decision describing the attempt to limit hours not a legitimate exercise of the state's police power to protect citizens. Instead, it simply encumbered immigrant bakers operating private businesses. Note, though, this case came out of a commercial corner, and it still sided with the property owner over police powers of the state. The judges stated, the police power would serve as a mere pretext and become another and elusive name for the supreme sovereignty of the state to be exercised free from constitutional restraint. 1900s due process. In the 1900s, numerous cases involving property foreclosure and due process appeared before the Supreme Court. These cases all dealt in situations with an explicit commercial agreement in place between disputing parties. In contrast, foreclosures by municipalities on private homeowners where no explicit agreement exists have never been presented to the High Court. Still, the conclusions of the court in protecting individuals involved in even commercial cases is telling, and therefore establishes a great barrier to non-judicial takes should private property cases come before the Supreme Court in future years. Historically, within commercial cases, because of the extensive use of borrowing credit in consumer purchasing, the Supreme Court confronted the problem of defining the degree of due process protection to be afforded owners of what has been called necessary property. Recent decisions of the court indicate a trend towards broadening due process protection for property. 1969 AD, for instance, the constitutionality of a Wisconsin wage garnishment procedure. A finance corporation had filed a garnishment complaint alleging indebtedness on a promissory note by Sinaiac. Sinaiac's boss answered the complaint by stating that he was in possession of wages due and that he would pay one half of that amount to his employee, which was a subsistence allowance provided by the state statute. In the lower courts, Sinaiac unsuccessfully sought dismissal of the 50% garnishment action on several constitutional grounds, including deprivation of property without due process of law. It took the U.S. Supreme Court to reverse the decision of the lower court. It took the U.S. Supreme Court to reverse the decision of the lower court. Justice Douglas, writing for the majority, stressed the fact that an interim freezing of wages from the filing of the garnishment action to the trial on the merit was as serious as permanent deprivation of property and may, as a practical matter, drive a wage-earning family to the wall. Okay. The majority considered wages property, needing protection under the Due Process Clause. The majority also expressed concern over the tendency of garnishment to deprive the defendant of a realistic judicial settlement because of the pressure on him to settle with the plaintiff and thereby pacify his employer. Here the court blocked an extortion dynamic. What would the court think about a municipal taking someone's home to collect property taxes, especially taxes they had no authority to levy in the first place? 1972 AD, another due process case showed the propensity of the Supreme Court regarding property protection in confiscation circumstances. In the Fuentes versus Chevron consumer case, Fuentes stopped sending an appliance merchant her monthly payment for a gas stove after a disagreement arose on servicing the stove. At this point, the merchant filed an action for repossession of the stove in conformance with the Florida procedure. Before Mrs. Fuentes received notice of the action, the merchant obtained a writ of replevin directing the sheriff to seize the goods from the Fuentes home. Along with the confiscation, the sheriff delivered notice of the underlying complaint. By virtue of a Florida statute, the petitioner was owed no prior notice and was allowed no opportunity to challenge the issuance of the writ. At first glance, this case appears to be about proper timing of notices, but during litigation, many property protection principles were cited that could easily apply to confiscation of one's home. I might as well do that one again. 3 blunders in one paragraph. Here we go. At first glance, this case appears to be about proper timing of notices, but during litigation, many property protection principles were cited that could easily apply to confiscation of one's home and not just a gas stove. These principles included substantial deprivation. Regardless of notices, the court deemed the taking of the stove to be substantial deprivation. Necessary property. The stove was necessary property needed to live. Grievous loss. Any substantial and adverse impact on one's private interest is sufficient to require due process protection. These rulings provide a rationale applicable to deprivations of all property. How about one's home or life savings? Overall, Fuentes and other cases show the court's disposition to protect property and the constitutional. Overall, Fuentes and other cases show the court's disposition to protect property at the constitutional due process level, even in commercial disputes. So far, the High Court has not faced a private property case where municipal confiscation of assets takes place without even a breach of a commercial contract as the basis. And so, after many decades of precedent regarding natural rights, due process, and Supreme Court involvement, the building blocks are in place to rethink taxation on personal property. Just as it took 100 years to sort out natural rights and slavery, the time has come to straighten out property. 2019. This brings us today and the aforementioned U.S. Supreme Court ruling to allow property cases brought up to the highest court. Until now, home property cases were not accepted by the highest court, with the court considering these state issues. But are they? When states go beyond eminent domain situations and brazenly take private homes to collect taxes, illicit taking squarely defies the Bill of Rights. Either through ignorance, corruption, or neglect, state judges let the practice stand. This may be why Judge Roberts opened the door. I hope he does not close it. Next, in the final segment, we will summarize our choices. A plea to Judge Roberts. Please protect our property. Part 8, the choice. Life, liberty, and property, or produce, consume, and obey. This is the final segment of the A Plea to Judge Roberts series. Here in Part 8, we weigh our choices. The 5th and 14th Amendments to the United States Constitution each contain a due process clause. Besides insisting upon proper administrative procedures in prosecuting the law, due process acts as a safeguard against the debasing of life, liberty, and property through government overreach. The antithesis of due process is socialism, which seeks to control the whole of society, leaving us to silently produce, consume, and obey in order to stay in the good graces of the powers that be. And so, to prevent life from becoming totalitarian and tedious, by design, the American system stands anti-monarchy and in the modern era, anti-socialist. With the law this clear, one must decide, are you for or against inalienable natural rights? One cannot have it both ways. Those who, in the face of our Constitution, rail against absolute property rights operate as socialists, making them de facto enemies of our law of the land. Certainly, socialists want the land, but not the country's philosophy. And as Margaret Thatcher said, it is the philosophy embracing life, liberty, and property that makes one an American, not the dirt one is born upon, nor the place one simply immigrates to. Though anti-American opinion is protected, not for a minute should anti-constitutional governance be accommodated, allowing it to tip our society socialist without formal constitutional amendments being made. Though the principles of life, liberty, and property have prevailed since Jefferson first laid them out, the need for court involvement has never been more apparent. Consider this folk song. This land is my land, this land is your land. This land belongs to you and me. Not true. Every parcel of American land is owned by individuals, corporations, or federal, state, and local governments. When rangers close Yellowstone Park, you must leave. It's not yours, theirs, or ours. In America, it always comes back to property. And keep in mind that Judge Roberts formally invited us to bring property cases to the U.S. Supreme Court. I asked the court to reinstate America's law of the land, retire property taxation,